Hi, everyone. I'm David Schwartz. I'm a partner at Thompson Hine and practice group leader of the firm's International Trade Group. I'd like to welcome you to today's SmarTrade Fundamentals webinar on imports, tariffs, and trade opportunities. This is the third in a four-part series focusing on the basics of U.S. international trade laws and regulations. During these four webinars, we have been walking you through the fundamentals and providing practical tips for dealing with day-to-day issues. This series will help both seasoned and beginning trade compliance professionals refresh their knowledge about the essentials of import, export, and sanctions compliance. I'm pleased today to be joined by my colleague, Kerem Bilge. Before we get started, there are a number of housekeeping items I need to address. First, today's program is being recorded, and we'll send a link to all attendees within 48 hours of today's presentation. Second, the presentation is intended for the general information of individuals and organizations on matters of current interest. The thoughts and opinions being expressed today are those of the individual panel members only and do not necessarily reflect the opinions of the panel members, clients, employees, affiliates, or Thompson Hine. The content should not be taken as advice, as the views expressed are for informational purposes only. If you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen to submit questions. We will answer as many of the questions as we can, both during the presentation and at the end of the webinar. If we don't get to your questions, we'll follow up after the program by email or phone. We'll be offering CLE, Continuing Legal Education Credit, for today's webinar. Please be sure to complete the verification of attendance survey. A link to the survey is included in the agenda that can be found in the handout section of the control panel, again located on the right-hand side of your screen. We will also paste the link in the chat at the end of the program. I'll announce the tracking code for CLE at the end of the program, at the top of the next hour. In the handout panel, you can also download a copy of the PowerPoint slides we'll be using today, as well as the bios of today's presenters, Kerem and myself. Again, thanks for your interest, and let's get started. Next slide, please. We're going to be tackling three general topics today, addressing the risks and opportunities associated with tariffs. We'll be talking about trade remedy laws, the anti-dumping and countervailing duties. We won't be focusing on safeguards. The second category we'll be discussing will be Section 232 and Section 301 tariffs. And the third category will be free trade agreements, particularly the US-Mexico-Canada agreement, which replaced the North American Free Trade Agreement during the Trump administration. Next slide, please. Why is today's discussion important to you? Because all these categories can impact how you do business. We've identified three key impacts. US market pricing. Increased trade remedy duties can help a domestic manufacturer of a particular product combat import competition by raising market pricing. US importers or foreign suppliers targeted by trade remedy cases and orders can find ways to legally reduce trade remedy liability through either changes in pricing behavior, both at home and in the United States, and through changes in supply chain sourcing and manufacturing affecting the country of origin of the product. Import costs. Tariffs can lead, obviously, to increased import costs. Applying the trade laws and free trade agreements to your advantage can help you find ways to reduce your tariff liability on imported inputs and products. Supply chain disruptions. Increased tariffs and product shortages can lead to supply chain disruptions. Knowing the trade laws and knowing the free trade agreements provisions can help you work around those disruptions to keep costs down and ensure trade flows. Next slide, please. Kerem will get us started with our deep dive into the trade remedy laws. Kerem?
Thank you, David, and welcome everyone to our SmarTrade Fundamentals webinar about tariffs and trade opportunities. I'll start off with a quick discussion about the trade remedy laws. We can next slide. Thank you. So, given that we're talking about the fundamentals, we'll start with the broader question of about so what is the purpose of trade remedy laws? So they're essentially intended to level the playing field for the U.S. producers that are injured by imports that are unfairly traded and sold into the United States, and these are called the dumped or subsidized imports. That is why U.S. and almost all other countries impose anti-dumping and countervailing duties on imports that are determined to be dumped or subsidized and materially injure the domestic producers in that respective country. The anti-dumping and CVD duties are legal under the WTO agreements, which explicitly authorize and provide a framework for the investigations, as well as how they should be imposed on certain imports. And the next question is what is dumping? So dumping is a form of price discrimination that is made by foreign producers or exporters when they're selling their products to the United States. It essentially occurs when a foreign producer or exporter sells the product at a price below its normal value, and the margin of the dumping is determined by the difference between the export price and the normal value. So what is normal value? Well, normal value can be the price at which the foreign producer sells the same or a similar merchandise in its own domestic market or to a third country market. And in some cases, the Department of Commerce would have to rely on a constructed value method to determine the normal value, which essentially means the production costs of the foreign producer plus an amount of for profits and selling expenses. And maybe it may be too much into the detail, but the reason that the Department of Commerce will have to rely on a constructed value is that sometimes the foreign producers do not have a viable comparison market, meaning that the volume of their sales in the home market or a third country is less than 5% of their volume of their sales to the United States. And in that case, the Department of Commerce relies on the constructed value method to determine the dumping margin. And finally, the export price, which is also used to calculate the dumping margin, is the price at which the product is sold to the first unaffiliated customer in the United States. And then the next general term is the countervailable subsidies. Well, the governments subsidize enterprises or industries when they provide substantial financial assistance to benefit their production or exportation of goods. But to be countervailable, a subsidy must involve a government contribution that confers a certain benefits that is specific to a certain enterprise, industry, or region in that exporting country, or that must be contingent upon exports or the use of domestic goods over imported goods in production. There are many examples of countervailable subsidies, but we listed some of these here. So essentially, a direct transfer of funds from a government to an enterprise or an industry would be countervailable, and these include grants or loans or equity infusions provided by the government to the industries, and it can also be in the form of the government or a government entity providing goods or services to a certain company or an industry for less than the market prices, the adequate remuneration. And in that case, there will be a subsidy that is countervailable under the laws of the United States, and the appropriate CVD margin will be applied for that company's products. Next slide, please. So in this slide, we essentially try to list 3 key agencies that are involved in making dumping and subsidy determinations and that enforce them. So the first one is the U.S. International Trade Commission. During an investigation, when a U.S. industry or a producer petitions the government for relief from imports that are unfairly traded, the U.S. ITC is charged with making an analysis as to whether there is a material injury to the or a threat of material injury to the domestic industry by reason of the dumped or subsidized imports. The U.S. Department of Commerce International Trade Administration, on the other hand, has almost a parallel investigation that focuses on whether the imports are dumped or subsidized, and if so, what is the margin of the dumping and countervailable subsidies that should be applied to those foreign producers that are being investigated. In general, an anti-dumping or countervailing duty investigation is completed within approximately 300 days and 230 days respectively, but these timeframes can be extended by the agencies if additional time is needed to complete the investigation. There are preliminary and final stages of both investigations, and if an agency makes a negative determination at any of these stages, then the investigations are generally terminated at that stage. Once an anti-dumping or a countervailing duty order is issued, all in-scope products are assessed a company-specific and all others margin at the entry, and these all other rates are typically calculated as an average of the company-specific margins for the companies that have been investigated during the investigation. And the CBP, the U.S. Customs Board and Border Protection, is the agency that enforces these AD and CVD orders at the border by collecting the applicable duties. So the International Trade Commission also conducts the sunset reviews every 5 years to determine whether the material injury or threat of injury continues to exist for the domestic industry if the applicable order is revoked at the end of that 5-year period. To make that determination, they look at various factors, including the capacity and the prices of the foreign producers, and make an injury determination. And if they make an affirmative determination, then the orders would be continued for another 5 years. And the Department of Commerce, on the other hand, conducts yearly reviews to determine the company-specific margins of the reviewed manufacturers and exporters for that year. In general, the Department of Commerce selects 1 or 2 mandatory respondents during those proceedings, and they're selected based on the volume of their exports during that review period. and as part of that process, the Department of Commerce typically reviews the data provided by the foreign producers to calculate, again, a company-specific margin at the end of each review. And again, CBP enforces those AD/CVD orders and the applicable duties at the border. Next slide, please. So in this slide, we try to give you some recent statistics for trade limit, the AD/CVD orders in 2022. So in 2022, there have been 28 new AD/CVD orders that were implemented by the Department of Commerce, and at the end of the year, in total, there were 662 AD/CVD orders, which is significantly higher, almost more than double than the number of orders enforced that were in place by at the end of the 2016. And again, in the last year, CBP collected approximately $6 billion in AD/CVD deposits on imports worth about $37 billion. Next slide, please. So in the next few slides, we'll talk about two primary tools that the federal government uses to investigate the circumvention or evasion of the AD/CVD orders that were implemented against a certain country and product. The first one is called the Anticircumvision proceedings. These investigations are conducted by the Department of Commerce. The circumvention occurs when a merchandise avoids the discipline of an existing AD/CVD order, and the statute defines three primary forms of circumvention. The first one, as you see here, is essentially when a merchandise that is completed or assembled in a third country or even in the United States from parts and components imported from the country subject to the existing AD/CVD order. And the second primary form of circumvention is when a merchandise that has been altered in form or appearance in minor respects, then in that case, the Department of Commerce can make a determination that sale of this product to the entry of this product into the United States without paying the AD/CVD orders is a circumvention of the orders. And the last one is called the later developed merchandise. This is essentially when a merchandise is developed after an AD or CVD order has been issued and has the same general physical characteristics and use and channels of trade and advertising as the merchandise that was originally subject to the existing AD or CVD order. And again, in that case, there can be a determination that sale of this product can be a circumvention. Once a circumvention inquiry is initiated, the Department of Commerce selects foreign manufacturers or exporters to determine and issues questionnaires to these manufacturers to make a determination and analysis as to whether there is circumvention for the specific products under review. The Department of Commerce generally issues its preliminary and final determinations within 150 and 300 days, respectively, unless of course, they can be extended if it's deemed appropriate. So if there is an affirmative final determination, typically those products are included within the scope of the AD/CVD orders that are in place, and whenever they enter into the United States, the applicable duties will be imposed on them. These determinations can be made on a countrywide basis or a producer or exporter specific basis. When it's made on a countrywide basis, it essentially means that all products from that country that fall under that determination will be subject to the applicable AD/CVD duties. And when it's made on a company-specific basis, it's as you can imagine, it means that the determination only applies to the companies that are named in those determinations. And finally, the Department of Commerce may also implement a certification requirement which would require importers to certify that the products are or are not covered by the circumvention determination at the time of entry. And based on that certification, the applicable duties will be assessed on those imports. Next slide, please. And the second tool was introduced by the Enforce and Protect Act of 2015, and the CBP can investigate evasion allegations of AD/CVD orders by certain importers for their products entering in the United States. And again, anti-circumvention proceedings targets the foreign producers and exporters, whereas the EAPA proceedings target the importers instead. And the EAPA allegations or requests can be made by any interested party, including other importers, domestic industry, or foreign manufacturers and exporters. Next slide, please. Thank you. So in this slide, we essentially try to list three main stages of an EAPA proceeding. So in EAPA investigation, I mean, unofficially, it starts when an uninterested party files an allegation of evasion. Again, it can be the domestic industry or even an importer alleging that another importer is evading the AD/CVD duties. Once a properly filed allegation is received, CBP will have 15 business days to determine whether to initiate the investigation. And CBP makes that determination based on whether there is evidence that reasonably suggests that there has been evasion in connection with these imports and by the named importers. The scope of the investigation usually covers entries 1 year prior to the initiation through the dependency of the investigation. And the second important stage in that proceeding is called the interim measures. So essentially, the CBP must determine within 90 calendar days after the initiation as to whether it should apply interim measures against the importers that are named in the allegation. And there has to be a reasonable suspicion of evasion to make that determination. Unfortunately, there is not a lot of guidance as to what reasonable suspicion means, but CBP typically bases its determinations of reasonable suspicion on information provided in the allegation, as well as other information obtained by CBP, for example, through the issuance of CF-28s to the importers, or even CBP's own research as to the allegations. So the interim measures may essentially require a single transaction bond or cash deposit on all unliquidated imports, as well as the future imports that are subject to the investigation. And CBP can take any other appropriate measures on liquidated entries to protect the revenue of the United States. And this means that for an importer that is named in an allegation and against which the CBP applies interim measures, there could be a significant AD/CVD liability for unliquidated entries that are within the 314 days liquidation cycle at the time the CBP makes that determination. There will also be an ongoing significant AD/CVD liability for future imports. And finally, there could be potentially some collection actions for unliquidated shipments by CBP. And the last stage of the proceeding is the final evasion determination issued by CBP as to the importers named in the investigation. So after the interim measures are put in place, the CBP will conduct its own investigation to determine where there is substantial evidence of evasion, and that an importer is evading the AD/CVD orders. And as you can see, these legal terms imply that the evidentiary standard required for final evasion determination is significantly higher than what is required for interim measures. But that said, the effectiveness of interim measures are quite high because they can subject an importer to a significant liability during dependency of the investigation. And finally, the CBP must conclude the investigation within about 300 days from the initiation, and if it deems appropriate, it can extend that time period to 360 days. Next slide, please. So in this slide, you see the statistics we pulled from the CBP's website about EAPA investigations. EAPA was enacted in 2015 and entered into force in 16. As you can see in this slide, there has been a significant increase in the number of investigations initiated and conducted by CBP in the recent years, starting with 2019 and increasing to almost 64 investigations in 1 year in 2020, and continuing to have that same kind of level in recent years. And the amount of duties collected as a result of those investigations also increased a lot. Next slide, please. Thank you. And I'll just finish this discussion off with some key considerations as to the EAPA proceedings. Well, they are very labor intensive, and they require short timelines from the named importers and foreign manufacturers during the investigation process, where CBP issues detailed questionnaires to importers and foreign manufacturers, and CBP's deadlines are typically short, usually about 3 to 4 weeks. There can be extensions, but still it will require a lot of information by the named parties, and in addition to that, all information must be translated into English when it's being submitted to the CBP, and it also requires participation from the importers and foreign manufacturers, as well as the exporters during the investigation, to incentivize the parties' cooperation with CBP's information requests. CBP has the authority to apply adverse inferences if the importer or the foreign manufacturer fails to answer the CBP's requests in a timely manner. Adverse inference means that CBP will rely on facts that are adverse to the importer or foreign manufacturer in making its final determination. And this usually results in an affirmative evasion determination, resulting in significant AD/CVD liability at the end of that process. And that's why for importers, it's really crucial to make sure that your suppliers are in line with and cooperate with you during that EAPA investigation process. And finally, unlike the AD/CVD proceedings, conducted by the Department of Commerce, EAPA proceedings do not have an administrative protective order. And as a result, only CBP can see the confidential information that is submitted by the parties, including the allegation on the docket of the proceeding. For the submitters, the only requirement is to provide a public summary of the confidential information. There have been a lot of litigation around whether this procedure provides sufficient due process to the targeted importers, which often do not see the confidential details of an allegation on which CBP makes evasion determinations. And this has been litigated, and most recently, the Court of International Trade determined that the CBP's procedures are consistent with the statute, and they were essentially upheld. It appears that it will be continued to apply unless CBP changes its procedures. So in the next slide, I will David will
Kerem, we received a couple of questions during your portion of the presentation. It's probably a good time to ask you those now.
Sure.
There were two questions, and they're related, so you might want to answer them all at once.
Okay.
The first question is, I'm planning to import a product. How do I determine it's subject to trade remedy duties? And the second question is it possible for me to obtain a ruling that my product that I'm importing is not subject to trade remedy duty?
Yeah, absolutely. So in order to determine if a merchandise is subject to an AD/CVD duty, an importer must review the scope of an AD or CVD order to determine whether your product falls under that scope. The FTAs classifications are listed in the scope of AD/CVD orders for convenience for the importers in making that determination. But the written description of the product that is covered by that scope is dispositive, and the FTAs classification may be misleading in some circumstances. And that's why inclusion or exclusion of an FTAs classification in the scope does not really determine whether a product falls under the scope of the order. And how, so like, I guess the next question is how to obtain a ruling that my products are not subject to the AD/CVD duties. Well, an importer or any interested party can request a ruling from the Department of Commerce regarding whether the product falls within the scope of an order. A scope ruling essentially clarifies what imported merchandise is covered by that scope. These proceedings do not necessarily modify the scope coverage of the order, and may be conducted independently of an administrative review. But the interested parties can ask the Department of Commerce to determine whether that specific products are covered by the order, by the anti-dumping or the countervailing duty order. And in addition to all that, so if you find yourself in a situation where CBP applies AD/CVD duties on a shipment that you entered into the United States, but you disagree with that determination, then you always have the option to protest that determination with CBP within 180 days after the entry has liquidated. So I hope that covers it.
That was comprehensive. I think you did cover it. I'll go ahead and launch into our discussion now of Section 232 tariffs. If you could go to the next slide, please. The Section 232 tariff, it's a provision of the Trade Expansion Act of 1962. The provision itself allows the federal government or any interested party, like a private company, to request that Commerce investigate the effects of specific imports on U.S. national security. Commerce may also self-initiate an investigation, and it can also do so at the urging of the president. We wouldn't be having this discussion if we were doing the presentation before former President Trump was elected in 2016. In the 20 years prior to the Trump administration, we had a total of 9 Section 232 investigations. Since 2018, we've had 8. The list here on this slide identifies recent investigations. If you go to the next slide, please. Interestingly, of all those recent investigations, only the steel and aluminum Section 232 investigations resulted in tariffs. And those tariffs were used as bargaining chips. During the Trump administration, permanent exemptions were granted to Brazil and South Korea for steel, and to Argentina for steel and aluminum in exchange for quotas. Australia was exempted from both the steel and aluminum tariffs, and eventually tariffs on imports from Canada and Mexico were removed, and a joint monitoring and consultation system was implemented. Under President Biden, the United States has reached separate agreements with the European Union, Japan, and the United Kingdom to replace those Section 232 tariffs on steel and aluminum with quotas. And you'll see in this slide the level of tariffs that still apply to those countries that haven't been able to negotiate either an exemption or a quota. Next slide, please. Believe it or not, even though those steel and aluminum tariffs were implemented a number of years ago during the Trump administration, the product exclusion process for these Section 232 tariffs is still ongoing. Because it's company specific and not product specific, companies can still take advantage of this product exclusion process. And if in fact they are paying Section 232 tariffs on steel or aluminum, they very much should take advantage of this product exclusion process. And this slide explains the details of that process, which still apply today. Next slide. Recently, this past spring, the ITC found that the Section 232 steel and aluminum tariffs have had an impact. U.S. steel and aluminum producers have been faced with a significant decline in imports, an increase in market pricing here in the United States, and as a result, they've increased their domestic production. On the flip side, downstream steel and aluminum users have experienced production decreases and supply chain disruptions, which has led to increased sourcing from domestic producers, which is a desired outcome of these Section 232 tariffs. There have been court challenges, just as there have been court challenges to the EAPA process concerning the Section 232 steel and aluminum tariffs and the Section 232 steel and aluminum derivative products tariffs, which were also implemented during the Trump years. And those court challenges have not been successful. The upshot of this is that the Section 232 tariffs are here to stay, and companies are going to need to continue to work around them. And of course, there are ways to do that legally, and we can help you with that. Next slide, please. Let's talk about Section 301 tariffs. Again, if we had this presentation before the Trump years, we would not have included a section on Section 301 tariffs. But times have changed. Next slide, please. The Trump administration requested this investigation targeting China and for practices of China, their forced technology transfer requirements, their theft of US IP and trade secrets, their discriminating and non-market-based licensing practices, and their state-funded strategic acquisition of US assets. In 4 rounds, the US government identified tariffs that would be applied to certain products imported from China. And here you have the list 1, 2, list 3, and list 4A. List 3 and list 4A, you should keep in mind because they come into play later in a court case that we'll be discussing. But you see here that the first round was implemented in mid-2018, and tariffs were still applied over the course of the next couple of years. And they're still in application today. Next slide, please. I'm sure anyone listening in on this call has probably been involved in one way or another with the product exclusion process involving these Section 301 tariffs. It led to an enormous number of product exclusions. Most have since expired. We still have some involving COVID-related products, and we still have a few hundred that are still in existence today and are currently scheduled to expire at the end of September. The one point I want to make about this product exclusion process, it's product specific and not company specific, like the Section 232 product exclusion process. So if you are paying Section 301 duties, Section 301 tariffs, you should check and see if your product might fit the description of any of the product exclusions that are still in application today, either the ones that involve COVID or the ones that have been extended through the end of September. Next slide, please. Under the statute for Section 301 from the Trade Act of 1974, there is a requirement that the Section 301 tariffs are still in place. You need to have a review after 4 years. And that review was launched last year, and it's ongoing now with USTR. As you can see, a lot of people weighed in on whether or not the Section 301 tariffs should continue. We expect a decision sometime this year, perhaps by early fall. And if we had to bet, we think that the tariffs will likely continue and that the USTR, as a result, will probably start back up the product exclusion process. The tariffs are now baked into pricing, baked into our economy. They're part of the status quo. And the Biden administration decided early on that that was one decision by the Trump administration that they were going to maintain because the tariffs can be used as a negotiating chip with China. Next slide, please. Probably everybody listening in is a plaintiff to the Section 301 tariff refund litigation, which is ongoing, challenging whether or not it was proper for USTR to impose Section 301 tariffs on products appearing on List 3 and List 4A. The litigation was initially brought in September 2020. In March of this past year, the CIT ruled against the plaintiffs and said it was proper for USTR to impose tariffs on those products appearing on List 3 and List 4A, even though it was many months after the initial report came out. The CIT ruling is now on appeal at the U.S. Court of Appeals for the Federal Circuit, and we're awaiting action there. Regardless of what the Federal Circuit decides, whether there's a rehearing or a remand, this matter is likely to be appealed to the U.S. Supreme Court. We'll find out whether or not the U.S. Supreme Court will certify it. What I can tell you is that this may not be resolved for quite a while. Next slide. Kerem is now going to address free trade agreements, in particular, USMCA.
Thank you, David. There you go. So yeah, we'll start with a very brief overview of like the free trade agreements. They're essentially an exception to the most favored nation principle of the WTO agreements. This principle requires countries to not discriminate between their trading partners who are also WTO members. And once a country grants a lower customs duty rate to another WTO member country, it has to do the same for all other members. But some exceptions are allowed, and FTAs are one of them. The countries can set up a trade agreement that applies to goods only within that group, and essentially discriminate against imports from outside of that group. And in this slide, you see a list of countries with which United States has a trade agreement with right now. There are 14 trade agreements with 20 countries. And in addition to that, which Japan, which is not on this list, has a recent agreement focusing on critical minerals with the United States. Next slide, please. So the rules of origin under the free trade agreements significantly differ from the rules of origin that apply to goods that are accorded non-preferential treatment at the entry. Under the non-preferential rules of origin, which essentially applies to any good that is that doesn't qualify for an FTA treatment. For those goods, the country of origin is the last country where a substantial transformation has occurred, meaning that there has been a change in name or character or use of the product. And the FTAs, on the other hand, rely on other methods like appraised value or tariff sheet methods to determine the eligibility of that product under the FTA's duty-free treatment. Just to give you an example, the FTAs with Israel and Jordan, for example, rely on the appraised value method, which means that the cost or value of the originating materials and direct processing costs should exceed 35%, should be more than 35% of the appraised value of the article. The tariff shift method, on the other hand, requires that the non-originating components should be sufficiently transformed in the FTA country to allow them that there has been a change in the tariff classification of those components when they processed in that FTA country into the final product. Next slide, please. So here you see a list of key dates for the USMCA. The negotiations were commenced in August 2017 by the Trump administration to replace NAFTA at the time, and the agreement was ratified and entered into force on July 1st, 2020. Next slide, please. So the rules of origin under the USMCA are largely the same as NAFTA. There are 4 categories that a product can qualify for USMCA duty-free treatment. The first one is wholly obtained or produced goods. These are goods that have been extracted or grown or raised in a USMCA country, and things like silver mined in Mexico or wheat grown in Canada. And the second category applies to goods that are produced entirely produced in a USMCA country using non-originating materials, meaning materials that do not qualify for the USMCA treatment. and they can still be accorded duty-free status, provided that the final product satisfies the product specific rules of origin. These rules of origin differ based on the heading and subheading classification of the final product. In some cases, only a tariff shift is required, but in other cases, for some products, there can also be a requirement for a regional value content threshold, meaning that the product should incorporate at least, let's say, 60 or 65% originating materials and processing costs as part of its transaction value or net cost. And the third category applies to products produced in a USMCA country using originating materials. This clearly qualifies for USMCA duty-free treatment, because the final product, as well as the inputs that are used to produce that final product, all qualify for USMCA rules of origin. And the last one applies to parts or unassembled or disassembled goods that are classified under the same heading or subheading as the final product, and thus they fail to meet the product specific tariff shift requirements. In that case, the goods can still qualify for USMCA duty-free treatment, provided that the regional value content of the good is at least 60%, or under the transaction value method, or it's at least 50% if the net cost method is used. And this doesn't apply to certain textile articles. Next slide, please. So we'll start. We have about 8 minutes, so I'll start with the examples and try to wrap this up in the next 8 minutes. So here you see an example that we pulled from a CBP ruling, which involves a supersede cereal product that is made in Canada from Brazilian origin brown sugar and Vietnamese origin ground cinnamon, among other originating components. So to determine if this product qualifies for USMCA treatment, CBP looked at the product specific rules for the subheading under which the final product falls, 1904-20, and according to that rule, there must be a change to subheading 1904-20 from any other subheading except for Chapter 20. Next slide, please. So under this, this product meets the required tariff shift requirement, because the non-originating components, the brown sugar and ground cinnamon, are classified under a different subheading than the final products, and they're also not classified under Chapter 20. So that's why CBP accorded duty-free treatment for this product. And the next slide, please. And the next example involves a metal watch made in Canada from Chinese watch springs. According to the product specific rule for Chapter 91, under which the metal watch falls, there are two options for a product to qualify for duty-free treatment to be originating. First, there has to be a change to headings 9101 through 9106 from any other chapter. In this case, the Chinese watch springs are classified under the same chapter as the final product. That's why they don't really qualify for option A. But then, if that's the case, then they can still qualify if the RVC is not less than 60% of the transaction value or 50% of the net cost method. So that's why we have to rely on option B. Next slide, please. In the first two bullet points, you see the formulas used for calculating the transaction value and net cost RVC percentages. So in this case, the TV refers to transaction value, VNM refers to the value of non-originating materials used by the producer in the production of that final good. And the NC refers to net cost, which means the total cost to produce that product minus any sales, promotion, marketing, or after-sales service costs, among others. So going back to the example, let's assume that the transaction value is $200. The net cost of the watch is $160, and the value of the Chinese watch springs is $75 for each watch. Next slide, please. Under the transaction, under both methods, this product qualifies for duty-free treatment because it's above the required thresholds under both net cost and transaction value methods. Yes, thank you. Next slide, please. So we'll briefly talk about the certifications of origin and the certain changes that have been made under USMCA compared to NAFTA requirements. So certifications are required to claim preferential treatment under the USMCA. They can be completed by the producer as well as the importers and exporters. NAFTA allowed only country of origin certificates from producers and exporters, but USMCA extended it to also importers. NAFTA also had a uniform certificate of origin that were required to be used for in all three countries to certify that the goods qualify for preferential treatment. USMCA doesn't have that requirement, but CBP has provided a template which can be used by the parties. These can be completed, submitted electronically, and they can cover multiple shipments of identical goods in a year period. And next slide, please. There are 9 elements that are required to be on the certification. And you see this list here. I think the most important part is the origin criteria. You need to make sure that you select the accurate criteria, which we just discussed. These like 4 categories that you think the product qualifies for. And the next slide, please. So in the next 2 slides, we'll talk. I mean, it's just a list of list of issues that are used in certifying the products for USMCA. This includes, I mean, the companies should have updated their compliance manuals and organizational charts and processes to account for the changes in USMCA. The classifications must be made properly. The determinations of eligibility must be made according to the General Note 11 of the Harmonized Tariff Schedule. And if there's a textile or automotive product, there must be a separate determination as well, which can require more stringent rules of origin. And you need to identify the suppliers from raw materials to finished goods, and that you need to make sure that you verify all the information provided by the suppliers. Thank you. And I think the most important thing to highlight here is that you need to, there's a 5-year record keeping requirement. So whenever you enter a product as USMCA eligible, you need to make sure that you retain the records for 5 years after entry. And then it's you can do monthly or random audits or verifications and request. You need to request certification from suppliers on an annual basis for identical products. Next slide, please. I'm wrapping up in 2 minutes.
Kerem, if I can interrupt, I apologize.
Yeah.
We did reach the top of the hour. Before you finish up your presentation, we do have one USMCA question that I think will be of interest to folks. But before we get to the rest of the slides and to that question, I promised folks that I'd tell them the CLE tracking code number at the top of the hour. We've reached the top of the hour. I hope people will stick around. The CLA tracking code number is TH9439. That's TH9439. Sorry for the interruption.
No problem. Thank you so much. And I'll finish it up in 2 minutes at most. As best practices, it's recommended that you trace your suppliers back to the raw materials of the products, and if it's not possible, confirm to the first extent the upstream suppliers and request that they certify for USMCA of those products, and in any changes to the goods made by the R&D or procurement departments or the suppliers should be notified to the entity or individual who is managing your customs operation. And then it's recommended that you keep separate sheets for any verifications you make in connection with the suppliers and internally. And finally, it's recommended that you have a provision in your contracts that require cooperation with USMCA certification process from the suppliers and providing the information in good faith. Next slide, please. And red flags, watch areas. Well, these are the trees that we came up with. In essentially, you need to make sure that the products that used to qualify for NAFTA treatment, duty-free treatment, may no longer be originating. So you need to make sure that you recheck your analysis if you haven't already. There have been certain changes in the product-specific tariff shift requirements. For example, there are more stringent rules of origin for automotive or textile products. And Section 301 tariffs may still apply for Chinese origin goods, even though they qualify for USMCA duty-free treatments. And that's because the substantial transformation analysis is separate from the USMCA rules of origin. And again, the marking requirements require a separate analysis and determination. So here we go. I think we're done. I'm sorry for being 3 minutes over the.
Well, Kerem, I mentioned that we did receive a question I think people would like to hear the answer for, and that has to do with the rules of origin requirements for automotive products under the USMCA.
Yeah. I mean, one of the most significant changes that was made by USMCA was related to the automotive products, because the USMCA significantly increased the required value content for those products to be eligible for duty-free treatments, and added a labor value content and steel and aluminum procurement requirements that they should be procured from North America, from the USMCA countries. Under the NAFTA, the RVC requirement was 62.5% for vehicles. USMCA increased this threshold to 75% for passenger vehicles and light trucks, and to 60% for heavy trucks. And the RVC ratios will increase to 64 for heavy trucks, will increase to 64% in 2024, and I believe it's going to be 70% in the next 6 years, 3 years after that. Sorry. So in addition to the RVC ratios, the manufacturers must also source 70% of their steel and aluminum purchases from USMCA countries. And in addition, again, finally, maybe not. In addition to that, the vehicle manufacturers must certify that I think about like 40 to 45% of their of their products come from a plant that pays at least $16 per hour to its workers. And finally, the manufacturer must ensure that the core parts that are incorporated into the vehicle, such as the engine, the transmission, the axles, or the steering system of the vehicle, are originating for USMCA purposes. I think it's worth mentioning that in early this year, a USMCA panel has ruled that in calculating the RVC ratios for the vehicles, manufacturers can roll up the originating core parts in the finished RVC calculation for the finished vehicle. And that means that the manufacturers can essentially disregard the value of any non-originating inputs used to produce a core part of the vehicle when calculating their RVC ratios. So this obviously provides an enormous amount of flexibility for manufacturers in meeting the RVC requirements by allowing the manufacturers to roll up these the non-originated to roll up the core part, the values of the core parts in their calculations. So yeah, I think we'll I hope this covers the question, and we'll keep watching any updates in connection with the USMCA in the future.
That was great, Kerem. Thank you. That was a great response. Again, for those of you who may have missed it earlier, if you're seeking CLE credit, the tracking code number is TH9439. This was the third of 4 programs in our SmarTrade Fundamentals series. Our final program will be July 27th on export controls, featuring my colleagues Samira Varma and Aaron Mandelbaum. If you're not currently receiving our updates and invitations, we invite you to go to the Thompson Hine website. If you could go back a slide, I think the information is available on that. There you go, perfect. You can register at thompsonhinesmarttrade.com to receive our mailings. I also encourage you to visit our blog, thompsonhinesmarttrade.com. Again, thank you all for sticking around past the top of the hour. I hope you enjoyed it. Be well, and we look forward to seeing you all at our next program, July 27th. Take care.
Thank you.